Well, welcome everyone to Washington Legal Foundation's web seminar. My name is Glenn Lammy. I am Executive Director and Vice President for Legal Studies here at the Foundation. For those of you not familiar with the Foundation, we are in our 46th year of public interest law and policy advocacy and education. Our website is WLF.org. We have a very well-trafficked blog, the WLF Legal Pulse, on there, and our site is filled with briefs that we filed on our litigation side, and publications and blog posts and past programs that we've done on our legal studies side. And I certainly encourage you to spend some time with that if you have a chance. I want to thank everyone who's joined us today in person, and also those who end up watching this as a recorded file. So on the heels of state litigation against tobacco manufacturers and the resulting master settlement agreement, state lawsuits aimed at businesses accused of warming the Earth's climate started popping up in the late 1990s. Defendants opposed these claims with numerous arguments, with the most potent seemingly being that the resolution of these disputes thrust courts into political questions that are non-justiciable. In a 2010 Washington Legal Foundation working paper, Harvard Law professor Lawrence Tribe and attorney Tristan Duncan wrote that, quote, courts squander the social and cultural capital they need in order to do what may be politically unpopular in preserving rights and protecting boundaries, when they yield to the temptation to treat lawsuits as ubiquitously useful devices for making the world a better place. Government lawsuits made their way through the federal appeals process until finally in 2011, the US Supreme Court ruled unanimously against Connecticut in AEP versus Connecticut. Now, instead of invoking the political question doctrine, the court reasoned that federal statutory law displaced the federal common law that plaintiffs relied on. In reaction to this, the proponents of climate change regulation through litigation regrouped, filed new lawsuits in state courts. After years of litigation over removal of those lawsuits to federal courts, this spring, the Supreme Court refused to review federal appellate court decisions that remanded several of those suits to state court. So at least some of the cases are now back in state court, and we imagine that there'll probably be others that will happen as well. So as these multi-billion-dollar lawsuits proceed, the question federal courts addressed in the late 1990s and the early 2000s remains: is the judicial branch the proper branch of government to pursue answers to the vexing questions posed by the planet's changing climate? We're pleased to have with us today a trio of speakers that are highly qualified to discuss that question. Before introducing them, I note that the program is being recorded, and if you have any questions, please use the Q&A widget at the bottom of the view screen. Introduce our speakers first. Phil Goldberg is office managing partner at Shook Hardy & Bacon's Washington, D.C. office and is co-chair of its public policy practice group. Phil also works with the Progressive Policy Institute on civil justice issues, and in 2019, he was named special counsel to a project of the National Association of Manufacturers, the Manufacturers Accountability Project, which Phil will talk a little bit more about in a minute. Joining us also is Sarah Hunt, who is president of the Joseph Rainey Center for Public Policy, where she leads public policy research and leadership development programs. Prior to founding the Rainey Center, Sarah launched a clean energy program at the American Legislative Exchange Council and a climate change program at the Niskanen Center. Early in her career, she practiced political law at a boutique law firm in the Pacific Northwest. Our originally scheduled third speaker, Jeremy Harrell, had a last-minute conflict, so we're pleased to have Matthew Mailloux, who has stepped in for him. He's a policy advisor at ClearPath, leading the organization's federal permitting and tax portfolios. In this role, Matt works across ClearPath's suite of technology areas to shape legislative and regulatory efforts, including new policy development. He joined ClearPath in 2021 in the office of New Hampshire Governor Christopher Sununu, where he served as state budget director and previously as the governor's energy advisor. So before we get into the questions and discussion, I wanted to ask each of you to talk a little bit about your involvement in this particular issue, and we'll have Phil start off with that.
Great. Well, thank you, Glenn, and obviously Sarah, and to Matt. Really enjoying meeting you guys and over the next hour talking about this important issue. Glenn, the WLF does such an amazing job with these programs and these webinars, and obviously Corey with the Make a Speak program, and so you're great partners in all of this. As Glenn said, I work with the Manufacturer Accountability Project, which is a project of the National Association of Manufacturers, and the reason that the NAM formed MAP, which is what we call it, is because of the concern that manufacturers are being sued for really are a wide variety of environmental, social, political issues that are somehow connected to products, and they say, okay, well, let's just sue the product manufacturers, and in lieu of dealing with the issue in the way it really needs to be dealt with, which may be in the regulatory or political branches of government. The claims themselves, and what we have pointed out, and we've got our website, the Manufacturer Accountability Project website, where there's a lot of good materials on it's breaking down some of the legal concerns, is that the liability is trying to be assigned here, irrespective of the facts, irrespective of the law. It's just to try to bring these lawsuits and hopefully try to get settlements or try to drive political or corporate behaviors, irrespective of what the law is. And then, so for example, public nuisance, which is one of the big theories here, it's about local disturbances and dealing with access to public road. There's nothing to do with global issues, nothing to do with things like climate change. Same kind of deal with Consumer Protection Act, which is also an issue here. We can get into all of that down the road. But where we come into this debate on climate change litigation is that we fully appreciate and understand the need to fundamentally change the way we source and use energy. Electrification over the past 150 years has been one of the greatest advances in society and human health and standard and quality of life. But how we've done that for these 150 years is not how we're going to do it for the next 150 years, and we all know that. And so we have to figure out how we make that transition, and the challenge is figuring out how we do that while still maintaining our modern society. It's not to sue people who provided that, that energy, and it's to say, okay, you need to now pay for this. This is something that that's a societal-wide concern, and that we've all known about for a long time, and it's one that we need to deal with, and we deal with it faster and more importantly now than probably any time in our history. What we disagree with is the value of the litigation in doing that. And so, the litigation is not going to solve climate change. It is, as I said, has no legal foundation, and it's frankly a distraction and unproductive from what needs to get done. And so that's why we are involved in this effort, in this debate, because we're concerned about the not just the precedent that this kind of litigation will set against all types of manufacturers, but particularly with respect to climate change, this is not an effective use of resources in trying to get things done and meaningfully address an issue that climate change presents to us.
Thank you, Phil. Sarah?
I put myself on mute to be polite. Thank you all for having me this morning. I'm Sarah Hunt. Really lovely to be on this panel with Matt and Phil, both thoughtful gentlemen. I started looking at this issue because at the Rainey Center, we work with state and local policymakers, as well as at the federal level. And we were hearing from, center-right policymakers in local government, in state government saying, hey, we want cleaner air, we want clean tech jobs, we want a healthy environment, we want affordable, reliable energy, but this municipality that's blue or that one that's blue in the neighboring state, they're filing these lawsuits, and it's making this issue more political. Obviously, they don't necessarily think, coming from a more conservative perspective, they didn't think the litigation was smart, but it was a concern because we're working with them to figure out a path forward that's smart on reducing carbon emissions, on adapting their communities to climate change, and also capitalizing on the opportunities that are there for the clean tech economy, for new jobs, for all of the above and all of the below approaches to, and a pollution-free, affordable, reliable energy system. And they see this politicization and the litigation as one more thing that's getting in the way of having those conversations constructively. And that's when I started to look into it. And what I found was it was not only having these negative unintended political effects in the execution of this litigation that are detrimental to the goals of the plaintiffs, but it was also having an effect on the innovation, research and development and deployment side. These companies that are being sued, our multinational, large American energy companies, are the partners that are necessary to help innovate the technology and deploy it and scale it in a way to address the carbon emissions and, energy independence and, clean, affordable, reliable energy issue that we are facing. So it really began to appear to me that this was a big problem and a bigger problem for the space with potentially very bad consequences if you care about getting to a solution, if you care about having the conversation. And that's why I started writing about it, looking at what was going on with the litigation, not just the legal arguments, but again, is this really going to help address the problem? Is it going to mitigate carbon emissions? Is it going to keep tons of carbon from going in the air, or is it going to help pull tons of carbon out of the air? No, in fact, it might have the opposite effect in setting us back by politicizing the issue and setting us back, if we bankrupt with damages, an important energy industry partner that is innovating in the space and has the capacity to deploy. So I wrote a paper about alternatives that municipalities can explore to litigation. And I've written a few pieces for Bloomberg. I write for them, and have just generally paid attention to this because I'm hearing about it from policymakers and their concerns. Again, to justiciability, it is absolutely a political issue.
Thank you, Sarah. Matt, if you could finish us up there.
Happy to, and thank you, Glenn, and thank you for the opportunity to present. And again, apologies that Jeremy was not able to attend today. My name is Matthew Mailloux. I'm a policy advisor leading our permitting portfolio at ClearPath. For those who may not be familiar with ClearPath, our mission is to develop and advance policies that accelerate breakthrough innovations to reduce and remove global energy emissions. And as we come into this conversation today, obviously permitting has been a key focus on Capitol Hill, and we see judicial review as being a core part of any sort of meaningful negotiation that may come forward. America's energy demands are rapidly increasing. Some estimates say that the US will need to double the capacity of the grid by 2050 to meet expected clean energy demand. To support that grid modernization and US manufacturing competitiveness, America will simultaneously need to construct tens of thousands of miles of new pipelines carrying natural gas, hydrogen, and captured carbon dioxide from power plants and industrial facilities. Financing and building enough of that clean energy infrastructure to meet the demand for reliable, affordable, cleaner energy is an immense challenge. But under the current regulatory environment, including after the fact judicial challenges, the pace necessary to meet these goals is procedurally impossible. Never has the phrase time is money been more appropriate. Regulatory delays that can last nearly a decade make projects more expensive, impede the US's ability to deploy billions of dollars in capital that would create American jobs, enhance US energy security, keep consumer costs affordable, and reduce emissions. The current system is clearly broken. The structures in place today are overwhelmingly tilted towards those who seek to delay or block projects, as opposed to those who seek to build. While that dynamic may have made sense 4 decades ago, when policymakers first enacted these laws as a response to environmental disasters, today those very same laws are being used to block projects that will reduce emissions and improve environmental quality. Instead, we need to transition to a system that promotes good outcomes, both economic and environmental. The pace and scale necessary to build clean energy infrastructure projects that reliably meet America's energy demand and reduce emissions is not something the authors of the 1970s environmental laws could have imagined. But fortunately, fixing this outdated, broken system has been at the top of the agenda this Congress. ClearPath is encouraged by the Fiscal Responsibility Act, including some basic common sense permitting provisions. And we hope that this is the first step in a bipartisan, game-changing process. It not only shows that both sides recognize the problem, but also that they're willing to actually move forward with legislation in a way that we haven't previously seen. Meaningful permitting reform, from our perspective, will address 3 key points: restoring predictability to the system, improving coordination between all levels of government, and most relevant to today's conversation, provide for a more streamlined litigation environment. Thank you, and I look forward to the ongoing conversation.
Thanks very much, everyone, for getting us started there. So even though governments from Hawaii to Hoboken are plaintiffs in these suits, the legal theories and remedies are really similar across the legal complaints. Phil, you talked a little bit about the causes of action in the beginning there. But could you elaborate on the public nuisance and the consumer protection aspects, and also talk a little bit about what kind of remedies are being pursued?
Sure, and that's a great question, Glenn. So as you indicated, this is a 20-year long story that's been told in the courts about climate change. And so back in 2011, you indicated in A.P. versus Connecticut, that was one of 4 lawsuits that was being brought at the time, and they tried to all these different variants of what was the idea was then federal public nuisance law. Those state public nuisance claims were also brought at the time, and so when the Supreme Court said that the federal public nuisance claims had been displaced, there was this effort, and there's papers on it. People who are involved in these discussions, have published their thoughts about how to repackage the litigation to try to achieve the same kind of policy goals they wanted, but not make it look like A.P. versus Connecticut, because the court said A.P. versus Connecticut, but more than just that, it was that this area of law was displaced. Because that courts aren't really the place to decide these kinds of issues. So you don't want judges on an ad hoc basis, case by case, deciding these issues. And that was a unanimous ruling written by Justice Ginsburg, she was seen as sort of the dean of jurisdictional issues like that. And it seemed pretty clear to everybody that this isn't, dealing with climate change isn't what the courts are for. And in fact, the Obama administration filed a brief in the case saying exactly that the causes of climate change are too vast. You can't have the kind of local nexus to litigation and causation and all those things that you want to see. And so liability wouldn't be principled. And everybody in the world would be included, and that's what the Obama administration said in their brief in the case. And so there was this effort to go through and kind of repackage the litigation. And so instead of federal public nuisance law, they started bringing a state public nuisance. Instead of going after the energy, there was the utility companies. They went after the producers. Instead of trying to get injunctive relief, which is what A.P. versus Connecticut was about, they said, let's just try to package this as money damages. But it's all driven towards the same goal. And so the public nuisance claims really haven't borne out in any litigation over the past 25 years to be successful when they're decided in the courts. When you go back to the paint litigation, opioid litigation, all sorts of litigations that are out there. When they get to state Supreme Courts, the courts say that's not what public nuisance is about. Public nuisance is about governments protecting access to public roads and waterways, and it's really a land and water use tort for local communities to stop those who might be unlawfully interfering access to the public roads. Consumer protection acts are about making sure that people get what they pay for. If you're going into a transaction, you want to buy a product, and there's advertising or whatever it is that drove you to that transaction, you want to make sure you're not being misled by those who are they're selling the product. They don't cover government speech, or political speech, what kind of lobbying efforts people are engaged in. That's not what you may disagree with it. You may not like it. You may think it's wrong, but that's not what Consumer Protection Act claims are really about. They don't govern that kind of speech. They govern when you get what you paid for. When you bought a gallon of gas, did you get a gallon of gas? And that's not what these litigations are about, and these challenges about either. But they started bringing in those Consumer Protection Act claims for 2 reasons. One is to amp up their rhetoric against the industry, because they're trying to say that, they knew this or they knew that or whatever it was. And so that allows them at least to talk more about that than maybe a public nuisance claim would. But more importantly, the past 5 years, they've been trying to figure out how to stay in state court, because they're hoping that they know federal judges will apply A.P. versus Connecticut and say, these cases don't belong in courts. They're not justiciable. They're not, they're policy issues. And they're hoping they're going to find a state judge someplace that's going to say, we're not going to follow that. We're going to do something different. And so in order to maximize their chance of staying in state court, they are using state law claims and particularly a state statutory claim they thought would be very helpful, trying to get them to stay in state court. And so that's why we are where we are in terms of these specific legal theories.
So it's not really a coincidence, Phil, is it that there are more similarities than differences among these complaints? There seems to be some amount of coordination.
Oh, for sure. As I said, there's coordination, at the front end. There are a lot of this is being funded by private foundations that are organizing and recruiting communities to bring the lawsuits. A lot of them are, they're just really just, cut and paste of the same arguments, which is really underscores why they're not appropriate. When anybody can bring a lawsuit under the exact same facts, it shows that they're not specific to the particular communities. It's a political decision of who's going to bring the lawsuits and who they're going to sue, because they're all suing different, combinations and permutations of companies, and the injuries that they're alleging are not particular to their own community. And so, this has become a real political football, and their goal, the people who are funding this and organizing all of this, is to just get as many points up on the board, as many lawsuits into the system, hoping that will just overwhelm the ability of the courts and ability of the companies to defend themselves. And then maybe they'll lead to settlement, lead to something else. It's not, and it's to, as they said, try to create scandal and try to delegitimize, this was one of the words they used, these companies in the political arena. It's not really about driving real liability law. People were hurt. They're now claiming recompense from those who wrongfully harmed them. This is much broader than that. It's a much more political, regulatory, legislative type effort that they're just trying to leverage the ability to file claims in order to achieve it.
So it would seem that the damages are more about mitigation and preparatory activities rather than the hopes that you'll end up reducing emissions here. Is that a fair characterization of kind of what they're really after here?
Well, it depends who you're asking. If you're asking some of the mayors who are bringing the lawsuit, that's probably true. If you're talking to people who are organizing, orchestrating, running the complaints and all of that, it's the other. It's they're trying to advance policy. The fact of the matter is how we as a society deal with these larger issues about the production and use of certain fuels, and how we're going to spend resources dealing with mitigation efforts around the country are federal issues that need to be coordinated at the national level. Not everybody kind of fighting for themselves and doing it through litigation that's not really founded in the law. And that's unfortunately.
So you had mentioned that one of the hopes, excuse me, of the campaign is that you'll get sort of a building of cases to the point where settlement becomes more advantageous or attractive. I mentioned the master settlement agreement at the outset in the tobacco context, but is it fair to say that there's not as much unanimity among the states or among municipalities here as there was sort of at the end of the tobacco litigation process? There are some that don't necessarily ascribe to this approach for dealing with climate
this
change.
Has been, and I think Sarah may have mentioned this before, but this has been highly political and contentious. You've had 15 or 16 states, AGs, weigh in against this litigation at every stage of this, because they don't want, whether it's, Baltimore, or Hoboken, or Boulder, Colorado, just, using this litigation to handcuff them in their states about what they want to do to deal with climate change. There are a lot of ramifications about this litigation that are going to be harmful to the effort to deal with climate change if all of a sudden the courts are making these kinds of decisions. So, where the response to the Russian invasion of Ukraine, dealt with needing to, the Biden administration saying, hey, we need more production of certain fuels because that's a national security issue for us, and because and for our partners, our allies in Europe, or if we're dealing with other affordability issues, and how are people going to be able to afford to put gas in their car, and you see that's a real challenge for some people, and the electric bills and all of that. So if all of a sudden the courts start driving the cost of energy higher, makes it more difficult to have energy independence and energy security, then it's going to make it more difficult for states, more difficult for the federal government to figure out how we're going to manage our resources, deal with climate change in a way that still allows people to do the things that we need to do every day. And so that's why there's a real risk to this litigation. That it's kind of it's a story that's not really being told as much.
Thank you, Phil. So Sarah, as you mentioned, you've done some writing that climate change aimed at litigation into climate change is at best a distraction and at worst entirely counterproductive. So tell us first why you think the litigation in general is a poor change agent in this context. And Matt, if you have some thoughts on that, I welcome those as well.
As someone who was an attorney who did impact litigation, I even filed a 1983 suit or two in my day around free speech rights, actually. Impact litigation, which is what this would be called, yes, it is coordinated. There are these efforts, but they're used across the spectrum of politics, coordination. You can see it even when red states were challenging the Clean Power Plan, for example. The coordination in itself isn't necessarily wrong, and the efforts to look at impact litigation in and of itself as a tool aren't wrong either. But one of the things you have to do as an advocate or someone who cares about an issue, if you're engaging in impact litigation, is assess how bad it's going to be if you lose. And what are the impacts if you lose? And often, just as bad can be unintended consequences were you to win. Phil outlined some of those in his recent comments, so I won't go too much into what he's already said, but you've got to think about if you are a plaintiff, a municipality, a local government, or even, the kids' climate lawsuits, they are generally losing. So they're creating bad precedent for their cause, in theory, by bringing these claims, by bringing them with these creative theories where you're trying to, fit a square peg into a round hole. I think that we have underestimated, at least those conducting this impact litigation, all of us sitting here watching it have underestimated how much harm they might actually be doing to the future. In terms of their cause. I also think that when you start looking at local governments, state governments, they have limited resources. Again, also really good to see some of the provisions that went into the Fiscal Responsibility Act. And that's all about saying we might be spending too much money sometimes as a country, and that goes across the board. So if we are a municipality and we care about climate change, how are we spending our resources? Are we spending our city lawyers' time? Are we hiring these outside firms to go and file lawsuits that we don't know if they'll have an effect or not, and we don't know if we'll recover damages or not? If we do, it would be potentially decades before we saw a check, when we could be investing those resources into, hiring an extra grants person to help us get IRA or IIJA money that's available, hundreds of millions of dollars, to municipalities to do things like weatherize or install energy efficient windows in their buildings. We could be looking at, revising our building codes, for example. Speaking of buildings, buildings are one of the major sources of carbon pollution. So, maybe you should revise your building codes to make it easier for people to permit their new energy efficient windows or their rooftop solar, or putting in charging stations for their employees in the parking garage. There's red tape around all of that. And a city could be spending money on policy experts and staff that could be fixing those problems that will lead directly to reducing emissions, instead of spending money on lawyers and lawsuits, which I understand as someone with a law degree. Lawyers and lawsuits are everyone's favorite thing to spend money on. everyone gets so excited about writing a check to their lawyer, right? That's why lawyers get retainers and get paid up front. Yeah, so I think that is an important consideration. And when you start, we don't have unlimited money in this country. We're in a time where the economy is we're going through inflation. Times are tough. People are tightening their belt. And I have to think that citizens in these cities might be sitting back saying, yeah, I care about clean air and affordable energy, and I care about climate change, but why are we spending our money on lawsuits instead of things that just make sense, that will actually lead to more sustainability in the short run?
Matt, anything to add?
No, I think, Sarah, you raise a lot of great points, and especially with the amount of money that has come from the infrastructure bill in particular, as communities pursue these projects, and we're very excited to ClearPath about the demonstration programs for new technologies, things like advanced nuclear, carbon capture, hydrogen in particular. But it's important to note that once these demonstration projects get through the permitting process, the same tools that are being used to block fossil energy projects are also being used to block clean energy. And it doesn't matter if it's a small solar farm next to City Hall or a multi-billion-dollar demonstration program. We see these challenges under NEPA in particular as being counterproductive. Congress has clearly authorized funding for these projects to move forward. And when you start to see opposition groups, and I'll use the transmission line in Maine that I'm sure many of you are familiar with, when groups that are ostensibly are worried about climate change and reducing carbon emissions are in court challenging a transmission line that would bring clean energy in from Canada, you start to see that we have mixed incentives as we try to prioritize financing for new technologies from Congress, and yet our permitting and judicial review system simply has not come around to the same conclusion.
ClearPath has spoken out on the imperative of innovative commitment from both the private and the public sector. One of the success stories that I thought was very compelling was the public-private cooperation to advance solar energy use. How has that effort found success?
Yeah, absolutely. And we see public-private partnerships as being core to any sort of successful transition. When we talk about American innovation, it's not only to reduce emissions here at home, but also from a global standpoint. If America can lead the world on these advanced technologies, advanced reactors in particular, and then export those technologies to allies and to prevent further influence from countries like Russia and China that are also trying to win these same sorts of proxy battles, it's critical that the US play a leading role. You mentioned the solar example. Another great example is the natural gas shale boom, where you saw early government funding working with the private sector to fund those initial projects and look at the trajectory that we're on. And now we're in a situation where we have so much capacity, we need to build more pipelines to be able to export that gas to Europe in particular. And as we've seen the Russian invasion of Ukraine, more American LNG to Europe has meant less capacity available for other parts of the world. Being able to predictably build this infrastructure to connect American energy to the global community couldn't be more important. And that, like you said, Glenn, a core part of what ClearPath supports and why we're so excited about the prospects of the infrastructure law. But if the money alone does no good if you can't cite the projects in the first place.
Sarah, has Rainey Center looked at all at the states, counties, and cities' use of carbon emission causing things themselves? Are there things that those government entities can themselves do to help reduce carbon emissions?
Oh, absolutely. In fact, here in Utah, I had a county commissioner over yesterday, and we were talking about some of the things that they could do, not just from a carbon emissions standpoint, but broadly looking at, clean air. I'm here in Salt Lake City. Clean air is a big problem here. What can we be doing that's cost effective and makes sense, at the local government level to clean up emissions? And, there are many things that are possible. The infrastructure law, I know some conservatives have misgivings about it, and rightly so, because of, the situation we're in with the national debt. But the reality is the money is there. It's line item to be spent, and governments should take advantage of it. And if you have the capacity, so investing in the capacity to pursue some of the programs and the grants that are available to local governments is a big step, and that we have worked with counties as well as cities and red states. They don't have a federal grants officer like the city of New York does. So figuring out how to give them more capacity and where they could build more capacity for themselves to pursue some of the funding that it's going to be spent, it's available. And again, how can you really disagree with easy things like improving the energy efficiency of government buildings, improving, even if say you put solar on some of your buildings, it's not just about clean energy, it's about if there's a disaster, we're going to be ready, right? We might have lights when we wouldn't otherwise. Those kind of things that can be done through this law, and making sure they have the capacity to pursue the funding is really important. There are other approaches that can be taken, I think, around, transportation too. Roads comes up a lot in this context. I had a conversation with a city in Louisiana a couple of months ago. Their state legislator had sent me to them to have a discussion around, well, we're here and we'd like to get some of this federal money under IDA to improve our roads. And guess what? That's the easiest way for us to improve our carbon emissions reductions, because and to improve the air quality in general, because we're in this northern Louisiana rural area, we're an agricultural area, and the way the roads are now, the big trucks that are transporting everyone's goods have to go like this. And if we could just build this bridge, it would reduce the amount of fuel, it would reduce the amount of emissions. And again, not just carbon emissions, but all of the things that come out of the tailpipe of a car, that aren't good for us. And when they go in the air, and those are counterintuitive potentially. Like you wouldn't think that building a bridge to cut the travel time of a big tractor trailer in a rural area would make such a difference, but it does. Another thing that we're seeing come up, which isn't per se about carbon, but water usage. Water is becoming an increasing, it's always an issue out west, it's becoming an increasing issue. But again, there are things that you can do, looking at energy efficiency, or not energy efficiency, looking at efficiency in your water usage. And all of the programs that you can put in to manage and monitor that. So those are things that are coming up too in general in this broader context.
So a question for both Sarah and Matt. Do you think that public officials at the state and municipal level really have a good grasp on the need for non-renewable resources to continue to be available now and in the process of transitioning to different energy resources?
I'm happy to kick that off, and Sarah, certainly, feel free to chime in on what I might leave out, but I definitely think we've seen that. And one example that ClearPath is very excited about would be Class 6 well primacy, or injection wells to sequester captured CO2. We've seen two states in particular, Nevada and Wyoming, gain that primacy. They're the first ones out of the gate. And they've been able to cut permitting times for those types of wells in half compared to what the EPA's process would entail. Same rigorous standards, but when you prioritize it at the state level, you're able to yield these results quicker. That has benefits not only for their state economies by allowing companies to operate and create jobs in these areas, but also add to that tax base as well. We've seen other states like Louisiana and some others continue to move through this process, but it's been a difficult and arduous road to get this administration in particular to advance these types of applications. That's just one example. I think as you've seen opportunities for these demonstration programs, we're very optimistic about the hydrogen hubs and how these types of large public-private partnerships can deliver tremendous benefits for these communities. And it seems that state and local governments and working collaboratively within the region are definitely mobilizing to go after these federal funds.
I think one thing that I would underscore is that while in some big blue cities, climate change might be a priority issue, in most of the country, it's not. That's just being realistic. I have a colleague at Arizona State. I am a director at a center there. He's in Bonn right now. He's in Bonn for the Bonn Intercessional. and there is a convening of cities, of mayors and local governments like counties. There is one US representative, one mayor from Des Moines. So I think that speaks a lot about the priority level here. One of the things that I like to say as someone who does care about the future, who does care about climate change, I'm originally from New Mexico, desert state. Climate change is water scarcity. But while the climate crisis may be real, the human need of the world is also great. And we cannot expect people to sacrifice basic needs today being met for something in the long-term future that they don't know about. And most mayors and local government elected officials in this country are dealing with that. They're dealing with that day to day of, I need to get the stoplight done. I need to make sure, another issue we're having here in Utah is flooding. Guess what happens when you flood? Mosquitoes, because mosquito larvae can be active for 20 years. And if they get wet, all of a sudden you have a ton of mosquitoes. And Utah County here just had to reappropriate some money to spend $5 million on mosquito larvicide because they ran out of larvicide. I mean, they're all, people are focused on those day-to-day issues. Now, when you talk about, do they see the need to continue to use, fossil resources? Their constituents want affordable energy, reliable energy, but they do also want it clean, and they also want clean air. And affordability is probably going to continue to be the priority. The good news there is that a lot of cleaner technologies like solar, they're very affordable now. And there are, there are programs under IJA and IRA that can help cities accelerate adoption of those resources in their city. But there's also things that they can do on the permitting and regulatory front to make it easier for consumers who want to put those new forms of energy into their buildings, into their homes, just to make it easier for them to do that. And I think cities are interested in that as well. I will close my comments on this front by saying, I always like to say I believe in materials science, and people talk a lot about keeping it in the ground, but the reality is it's very hard to make a PV cell or a solar panel without petroleum byproducts. It is the same for a wind turbine. There's a lot of copper in a wind turbine. There's a lot of mined rare earth minerals in a battery. The lubricants that they use to run wind turbines are usually petroleum based. That doesn't mean our technologies won't advance in the future and they won't need to use petroleum to make wind and solar, but for now they do. So if you want to move away from fossil resources, you can't even have wind and solar deployable at scale.
Glenn, I
Matt,
think.
Go ahead. Sorry, Phil.
I think that, the American people have always been people who are willing to sacrifice one to do their part. And the goal of this litigation, those who talk about it has said, our goal is to raise the cost of energy, raise the cost of these fossil fuels so that they become more expensive. People will use less of it because they won't be able to afford to use as much. And I think if you ask the American people, are you willing to sacrifice and in this way, the answer may be yes, but only if it's actually going to achieve the end game that we're all trying to get to, which is to reduce the impacts of climate change. When you're asking them to do that, but in like a day, China or someplace else around the world is going to emit more carbon than we're going to be saving, then you're sacrificing for nothing. If you believe in reducing production of fossil fuels, then there's a great article in the New York Times last year where they interviewed the CEO of Saudi Aramco saying, as American companies start reducing their investment in fuels, he said, of course we're trying to benefit from the lack of investments by major players in the market, and they're going to increase their control of the oil market. Or OPEC is from 55% to 75% over the next 20 years, according to this article, which is only going to hurt our national security, hurt our energy security. And so you have to try to figure out how we're going to balance all of these things. and which is why this is a global issue. This is why if we're going to do something on climate, we're going to be effective on it. It's not just about, thinking in sort of our own American way that what we can do here is going to, of course, going to translate. It has to be at the global level. It has to be bringing all of these others into the same solution, so that we're marching, so that what we're doing is going to actually have the effect of what it is we want, which is reduce overall emissions and reduce the impacts of climate change.
Matt, did you want to add anything?
No, I'm good. Thank you, Glenn.
Okay, well, I have you. One of the major things that ClearPath talks about is to look at emissions from a sort of broader based focus and not be too narrowly focused on one particular industry or one possible cause. Is it difficult to maintain that focus when you have these lawsuits that are so focused on one particular industry and one particular product that is allegedly causing this?
Well, I think it's important to focus on what the overarching challenge is. And if we're focused on reducing emissions, we approach that from a technology neutral standpoint, that you can reduce the emissions and not attack the fuel source where they come from. And that's not just ClearPath that has said that. That's the Intergovernmental Panel on Climate Change at the UN that says we're going to need carbon capture in a fairly substantial way under any circumstance to actually achieve any of these goals that people have set forward. So that's why ClearPath, we support a broad suite of technologies. We know that not all of these are going to be successful at the end of the day, but that's why these public-private partnerships are so critical. And to Phil's point, if America doesn't lead and we don't develop these technologies to export, we are going to cede ground to other countries around the world. And we certainly would favor American ingenuity and American innovation over attacking any one particular source. And just on one other note, what we've seen is these same companies that are being challenged in court are also some of the largest investors in these next generation technologies. And while we support early stage startups applying for these funds, you also see some of the oil majors playing a very active role in chasing these demonstration projects. And ultimately, success can come from any one of those avenues, regardless of what their bread and butter might be today.
Let's finish up here where we started, which was on the lawsuits themselves and legal theories. Phil, which cases do you think that people should be paying closest attention to over the rest of 2023?
Well, that's a good question. The ones that seem to be let's say this, as I think you indicated a couple months ago, the Supreme Court decided not to hear the last of the jurisdictional challenges, and so now those cases are going back to the states. And so I think we're going to see a couple of things happening. There's going to be a recruitment effort by those bringing the cases and underwriting and funding all this to get more people to file lawsuits. And then, because again, their goal is just to kind of put these points up on the board and kind of leverage their ability to file lawsuits in order for their policy gains. And then the other side of this is the lawsuits that were before the Supreme Court that are now being directed into the state courts. You're going to start seeing just regular old motion practice and figuring out, kind of how these lawsuits go forward. And so in Hawaii, there's that's got right now some of the key issues of before the Hawaii Supreme Court. In Boulder, the Boulder case has already started going forward in terms of teasing out some of those key issues. I think Baltimore is going to be one because that was one of the original cases. Hoboken, they've now, Hoboken lawsuit just seems like one of those, throw as much legal spaghetti on the wall and see what sticks. They now added state RICO claims. Puerto Rico's got federal RICO claims. I mean, it really is, it's not all of a sudden when all this starts happening, you realize it's really not about legal theories at all. It's just about the desire to want to sue. And so we'll start seeing how these different cases and legal issues play out, and whether or not you look at the states look at public nuisance the same way, the Supreme Court did when they were looking at federal public nuisance. So you're gonna look at, you're gonna see a body of case law starting to develop. And the key ruling that's out there, that's kind of what everyone's going to point to is when the New York City brought its lawsuit, it filed it in federal court, not state courts. There were no jurisdictional issues, but the federal court hearing it and the U.S. Court of Appeals for the Second Circuit affirming it kicked the case out, and they said, these lawsuits defy economic reality. There are so many more causes of climate change. These are not justiciable in a normal way that a lawsuit is. And so that's the kind of what the federal courts have said. And again, I started off this, the people bringing these lawsuits are desperately trying to go find a state judge and aren't going to, they won't follow the precedent that's been out there in the federal judiciary.
I'll remind everyone, if you do have a question, please type it into the Q&A box at the bottom and we'll address it to our speakers. Phil, there was a document filed in the Suncor case involving County of Boulder, which was one of the cases that the Supreme Court sent back down. Any thoughts on that?
Yeah, I mean, that was the motion dismissed based on some of the underlying claims aren't viable. And so, I thought it's a fairly short brief, but there must be page limits involved, but I thought it was a very clear and straightforward explanation that these are really federal issues, that public nuisance law doesn't pertain to this type of allegation, that Consumer Protection Acts don't complain to these types of allegations. And so there's really no law supporting any of these lawsuits. And so I thought, the lawyers who filed the brief did a great job getting to the core issue, which is there's no law supporting liability for selling us the fossil fuels or selling us the fuels that we've needed for the past, several decades in order to be part of modern life. Again, how we use and source energy going forward, and we're already doing that. We're already, making progress in that transition. That's going to change. I don't think anyone's disagreeing with that. But looking backward and saying that, that selling us energy to turn on our lights and heat our homes and drive our cars was a liability inducing event, I think that's going to prove to be a non-starter.
Yeah, a development that looks like it might be interesting is that a lower court in Hawaii certified the questions that are in that case to the Hawaii Supreme Court. Is that one people should be paying attention to as well?
Absolutely. Yeah, it originally was up to the mid-level court, and then the cities actually asked if it could go right up to the Supreme Court, and I think that's where it's headed to. And I'm not sure exactly what the briefing schedule is there or how long it will take, but that is certainly one to watch.
So we do have a question from one of our viewers. Are you concerned with the Montana's youth-led suit, which getting to trial just now, attracting quite a bit of national attention? You think that it might spur similar lawsuits, not just against governments, but against the industry? Bill, anybody have any thoughts on that?
It's all part, I go back to, it's all part of the strategy of, let's try to use litigation to drive policy. I think what's ironic from where I sit is that, these lawsuits are saying, the governments knew about this, they didn't do enough. The lawsuits against private industry is saying they knew about this and they didn't do enough. They didn't tell anybody. But meanwhile, even in their complaints, they acknowledge, that, this was known in the Johnson administration, and there were, public studies and public meetings where these things are talked about in the 70s, and NASA testified in the 80s now. And as Matt was saying, international organizations, looking at this for decades, they're all just trying to blame everybody else and try to figure out who they could sue and try to drive policy changes. And again, this isn't about litigation. It's not about liability. It's not about lawsuits. It's about innovation. It's about how we're going to innovate our way out of the situation that we're in, not how we're going to litigate our way out of this, because that's just not possible. Lawyers don't make fuel more efficient. Lawyers don't make energy more renewable. We need innovators to do that.
The Montana suit is something I know a little bit about because WLF put out a paper last week by a couple of attorneys with Idaho's Attorney General's office. Montana case is interesting because it's been brought under Montana's right to a clean environment amendment to their constitution. So it's a little bit unique in that sense. And also it was brought against Montana and challenging some of the policies that they themselves feel that the plaintiffs feel are advancing climate change within that state. So certainly not every state has a clean environment amendment, but those states like New York and Pennsylvania and others, you might probably see some of these kind of cases going forward. Another question. What are the unintended consequences of these lawsuits other than limited resources of municipalities? Why can't they do both, addressing climate change and seeking money from fossil fuel companies? I'll open that up to anyone who would like to answer. Sarah, do you want to take a crack at that?
I'm happy to hop in. I think one of the unintended consequences that I pointed out are the precedents that are being created. For the most part, this litigation is struggling, and I think it's very likely that the plaintiffs will end up unlikely to recover any money at all, while creating very bad precedent, especially given the legal theories that they're trying to use. So that's something to keep in mind. And it is a genuine concern and unintended consequence if we're looking at a situation where these companies, that as Matt pointed out, they are huge investors in the new technology, but more importantly, they have the capacity to invest in the scaling and deployment of new technologies. Resource constraints there will lead to increased emissions down the road. And thinking about it further, when you get into real liability, real fiscal liability for damages around climate change and emissions, none of these are traditional tort lawsuits, really, but we have joint and several liability. We've got other concerns and defenses that could be raised. Here we have the government right now, even in IRA, touted as major climate spending, investing hundreds of millions of dollars into fossil-based clean technologies, things like carbon capture. The government invested in fracking. Obviously, the government has immunity. They're not going to be sued, but how do we, as a matter of policy, as a country, allow companies to be sued for being in the fossil sector, for doing things that produce emissions, say even fracking, which the government invested a ton of money into for national security reasons, for energy and for energy affordability reasons, for supply chain reasons? How do we then say, okay, you're going to be liable for doing something that was not only allowed, but also funded by the government? And this is a global problem. We could bankrupt every multinational oil company in the US and still not be close to what some of the estimates are for climate change damages, adaptation, and mitigation. I am concerned, if a company has gone out and they have made fraudulent statements and intended to mislead the public, obviously they should be held accountable for that. But that's not necessarily what all of these lawsuits are about. And, we've even looked, those lawsuits have not been very successful. If you look at the Massachusetts and New York litigation around Exxon a couple of years ago, Exxon won that case, and a lot of it was about whether or not they committed fraud. So I think, there is a difference between saying a company committed fraud and lied to the public in the selling of a product, and looking at most of these companies, which I think would argue we were using the best available science at the time. We were engaged in activity that was subsidized by the government. I mean, we have been subsidizing our energy industry since, John D. Rockefeller back in the early 1900s. They were making choices based on the law and the science at the time. And as long as they weren't committing fraud in the process of doing so, as a society, we need to stand by that. Another thing that I want to point out here that hasn't come up yet, and I think is important to note, is unique in the world is our tort system, and also is the fact that our energy companies are privately held. Most energy companies in the world are state-owned enterprises. All of, China's energy companies, they're owned by the government of China. This is why we have Royal Dutch Shell. This is why we have British Petroleum, Saudi Aramco. Here it's ExxonMobil. It's not US ExxonMobil. And in that context, when you're looking at US global competitiveness, again, and this gets to the justiciability and political question problem, but say we did hold our fossil companies accountable for emissions contributions to climate change, and let's say without a fraud angle, right? To say they did that. I mean, that was the big thing in tobacco. It was the fraud angle. It wasn't so much that people got cancer, it was that they deliberately lied about it and it was provable. But let's just say that we did that. Our domestic energy industry would be the only energy industry in the world on the hook for that, because everywhere else they'll essentially have immunity or not be suable at all, because most places don't have tort systems because they are government-owned energy producers in those countries. And I think that's something that's important to keep in mind as a potential unintended consequence of how seriously this can hamper our domestic energy industry, which we need to innovate for clean technology, and we need every single day. It's virtually impossible to touch a product or get to work or go about your life and not have something that the fossil industry in this country helped produce.
Thank you, Sarah. Phil, Matt, any final thoughts on that question or just in general? Seeing none, I guess we will. I'm sorry, Phil, go ahead.
No, that's it. Good for the order. I appreciate the opportunity to be on the panel and to discuss this important issue. And I think as we all look forward to seeing, to how this litigation plays out, I think it's important to just remind ourselves of, what is the actual, underpinning of the legal underpinning of these lawsuits? What are they alleging? How, and what is the global responsibility for all of this? And I think that the main issue where a lot of this litigation is going to fall apart is when they get to the issues of causation. Even if the court is willing to fudge the legal liability standards, which frankly, are lacking for the reasons I said before, just, looking at causation, even, those advancing this litigation have acknowledged that they just don't have that yet. And so I'm sure they're busy trying to work up some scientific models to try to figure out how they could try to make that connection, but it's just not going to exist in any kind of real scientific way. And so that's just the litigation is probably going to fall apart on that, if nothing else.
Thank you, Matt.
No, just thank you, Glenn, for having us. And again, apology that Jeremy wasn't able to join, but really appreciate the conversation today, and obviously a lot more to do in the months ahead.
Yes, there will be much more to talk about. There's no question about that. But thank you for talking about what we did today. And thank you everyone for joining us. Everyone has a good rest of the day.